Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
Liberty Counsel files a brief at the U.S. Supreme Court defending parental rights. I'm Matt Staver, founder and chairman of Liberty Counsel and dean of Liberty University School of Law. Joining me is Matt Barber, vice president of Liberty Counsel Action and associate dean of the law school. Matt, we filed a brief recently at the United States Supreme Court in the case, and actually in a couple of cases there. It involves a social worker and a deputy sheriff. They went to a 9-year-old girl's school, and they took her out of class. They interrogated her for about 2 hours without ever notifying her parents or getting consent from them. And the mother was not even the subject of the investigation, so there was no wrongdoing with this child. Now the parent has filed suit against this social worker and the agencies, and the case is now before the United States Supreme Court. And the question here is whether or not these state social workers violated the Fourth Amendment protections against unreasonable searches and seizures that must be honored regardless of whether the investigation takes place at the school or in the family home.
Yeah, Liberty Counsel, we spend a lot of time dealing with First Amendment issues, but occasionally these Fourth Amendment issues arise. And here we have a clash of parental rights versus the clear, important ability of law enforcement, yes, to be able to engage in investigations of alleged wrongdoing against children. But here, it's the facts of this particular case are pretty clear that law enforcement has overstepped and has encroached upon parental rights. So as we see this erosion into parental rights and in this nanny state that continues to grow, parents are losing rights to help determine the path that their children will take in terms of education, sex education, and so this is an important case because we need to try to reinstate some of the parental rights that have been taken away in kind of a frog in the pot of boiling water type of situation. So I'm glad to see that we are getting involved in this. As amicus brief, I think we've made a very strong argument that certainly in this particular instance, officials overreached.
That's right. Well, obviously we need to begin by saying that certainly there are legitimate grounds and criteria and procedures for government to get involved whenever there is child sexual abuse or other kind of abuse or neglect. But at the same time, the government still needs to honor their parental rights and honor the Constitution. They are not immune from the Constitution. They're not freewheeling government actors that can do whatever they want to. And if you've ever been involved in any of these kinds of cases where the government comes in through Child Protective Services to investigate, and you know somebody who has been investigated or you've heard about them, you hear all these horror stories about how they come in, they do whatever they want to. They take children away for no real good reason, and they violate the rights of people. We actually had a case out of Wisconsin where this similar situation happened, and we filed suit against the social worker, and we ultimately won all the way up to the Seventh Circuit Court of Appeals. It was a case where, very similar to this, the social worker went into the school without the parents' knowledge. They simply told the principal they needed to have a interrogation of this one particular child, and the principal doesn't know whether the law says that that's permissible or not, so he allows them to go in. The social worker's in a room by herself with this child, has the child strip and look, and so it embarrasses the child. It really causes a lot of problems for that child, and there was no charges ever filed. Well, we filed a lawsuit against the social worker, and it was upheld on appeal. And there the court also found that the social worker and that agency violated the Fourth Amendment rights of the child and particularly the parents.
Again, it's important to emphasize we, if as much as anybody, Liberty Counsel and we as individuals understand a need to go after child sexual predators. We are at the forefront in fighting to protect children from this culture that really is pushing sexual anarchy and pushing kids into behaving in even sexual relationships with adults and so forth. But I can tell you, for instance, my father has been a counselor for children who have been sexually abused, physically abused for decades, and he has had to deal with social services in various settings. And I think that the government has simply been granted too much leeway and power to act arbitrarily without really even citing a significant evidentiary reason for pushing forward, is the case you mentioned with the strip search in the elementary school. So we need to rein back, I think, a little bit these social workers and government entities that have really been abusing the power that they've been granted to protect children.
That's right. Well, this case is up on appeal at the U.S. Supreme Court. A decision will be handed down no later than June of this year. Liberty Counsel filed the brief in this case. The cases are called Alford versus Green and Camretta versus Green, and it involves a social worker and deputy that went to a 9-year-old school, took her out of class, interrogated her for 2 hours without ever notifying the parents or getting the consent from
And that's
the parents.
the kicker. They never notified the parents. If they had spoken with the parents, talked with the parents, had the parents there to be a support to the child who was obviously afraid and wondering what's going on, did I do something wrong? But the fact that the parents were kept out of the
and the mother wasn't even the subject of the investigation anyway.
Exactly.
So there was no reason why they could not call in the mother while the child was being interrogated with the mother's consent and with the mother's presence there. But no, they bypassed the parent. And oftentimes what you see is government officials just thinking that they're the parent and they can override parental rights. And the problem is when you start doing that here, it is a domino effect, and ultimately parental rights become undermined in every other area. That's why in this other case, the Michael C. versus Griesbach case, that's the case where we filed suit and the Federal Court of Appeals upheld the case. It was a case arising out of Wisconsin where they actually strip searched a minor, and the court found that that was a violation of the Fourth Amendment. And our brief explains that school officials, while they have been provided some leeway in conducting searches related to maintenance of order and discipline, those relaxed standards for school officials should not be applied to non-school personnel that simply come there because that's where the child is, conveniently away from the parent, and then they take the child away and interrogate them. And that can have a very traumatic effect and impact on that child.
Aren't these two cases just really examples of the larger issue here and the larger problem, which is who is raising our children? Is it the parents, or is it the nanny state? Is it a government? Now, we know that the left, for instance, through pushing comprehensive sex education in public schools, and they seek to erode parental rights and have the government and officials step in to push their particular ideology, groups like Planned Parenthood and now the National Organization for Women and so forth, going through and actually providing curriculum in the public schools to teach children sex education. We've seen attacks against parents who are homeschooling. You hear about parents being threatened to be thrown in jail for homeschooling their kids. So isn't that really the larger issue here, Matt? Isn't it just an attack against parental rights that we're looking at the larger picture?
It really is an attack against parental rights, and some cases that are already out there are cases where the schools are having these very radical, very objectionable sex education programs. It's basically sexual propaganda programs. Parents object to it. They say, at least allow my child to be opted out. Mm-hmm. The school says, no, your child has to be here. And some parents in some parts of the country have challenged those laws and lost. And the court, for example, out in California, the Ninth Circuit Court of Appeals in a California case essentially said, once you drop off your children at school, then your parental rights stop at that schoolhouse gate, and the school can do anything they choose, and your choice is not what happens when they're in school. Your choice is whether you drop them off there or you drop them off at a private school or you keep them at home. That's your choice, they said. But once they're in school, then the school has complete autonomy to do what it wants to. That's the ultimate erosion of parental rights.
Federal judge out in Massachusetts, Judge Wolf, said that parents who complained that their children were being taught the radical homosexual agenda in public schools, they said, well, we have gay marriage in this state. You can either take them out and put them in a private school, homeschool them, but if as long as they're in the public schools, those are your only choices. You cannot opt out.
We'll give Liberty Counsel a call at 1-800-671-1776. Go to lc.org. You can ask for David Barton's book. We have that available at Liberty Counsel. It's called Original Intent. That's the book, Original Intent, for a contribution of $15. We will send it to you right away. And we also have the Patriots Handbook. And that Patriots Handbook has the Constitution of the United States, the Declaration of Independence, and Patrick Henry's famous Give Me Liberty or Give Me Death speech. You can order that by going to lc.org today.
You have been listening to Matt Staver of Liberty Counsel. Our hope is to encourage and inspire you to stand up for your faith, family, and freedoms. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email update. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.